How property affects obligation. How then are purely equitable obligations created? For the most part, either by the act of the third persons or by the equity alone. But how can one person impose an obligation upon another? By giving property to the latter on the terms of his assuming an obligation in respect to it. At law, there are only two means by which the object of the donor could be at all accomplished, consistently with the entire ownership of the property passing to the donee, namely, first, by imposing a real obligation upon the property; secondly, by subjecting the title of the donee to a condition subsequent. The first of these the law does not permit. The second is entirely inadequate. Equity, however, can secure most of the objects of the donor, and yet avoid the mischiefs of real obligations by imposing upon the donee, and with notice, a personal obligation with respect to the property. And accordingly, this is what equity does. It is in this way that all trusts are created and all equitable charges made, i.e. equitable hypothecations, these Greek words, or liens created by testers in their wills. In this way, also most trusts are created by acts inter vivos, except in those cases in which the trustee incurs a legal as well as an equitable obligation. In short, as property is the subject to every equitable obligation, so the owner of the property is the only person whose act or acts can be the means of creating an obligation in respect to that property. Moreover, the owner of the property can create an obligation in respect to it in only two ways. First, by incurring the obligation himself, in which case he commonly also incurs a legal obligation. Secondly, by imposing the obligation upon the third person, and this he does